Hi, everybody. This is Paul Hitchcock with Wealth Protector TV. Really fired up to have attorney Steve Williams with us today, who's a landlord attorney. Steve, you there? You can hear me okay?
I am. I can hear you great.
Fantastic. Well, you and I were talking offline. I'm looking at my notes here, and a very hot topic you were telling me about, which is fair housing and then rules regarding disability when it comes to landlords and tenants. So what's that all about?
Yeah, well, first, fair housing, that is a broad term that is codified in several laws, federal law, state law, and many local laws as well. And what it does is it prohibits discrimination. So these fair housing laws prohibit discrimination against persons of certain protected groups or classes. Commonly people are aware you can't discriminate against a person based on race, color, sex, religion, national origin, disability. Those are some of the main ones. But the list has grown significantly over the last decade or so, particularly at the state level and very many local levels, like San Francisco, for instance, where I do a lot of my practice is focused in that area, and I help a lot of people in that area.
Right.
So it's expanded to include, for instance, citizenship, immigration status, source of income, marital status.
And when you say you can't discriminate against these expanding classes, does that mean, like, for instance, not renting to them or jacking up the rent to get them out? I mean, what is discrimination?
That's right. So you cannot take any adverse action. You can't take action against someone in any area of housing, whether that's renting, whether it's purchase sales, whether it's condominium associations, virtually any area of housing. A person cannot take adverse action against someone based on one of those protected categories. And for instance, an example might be, a unit is on a second floor, for instance, and someone who has a walking disability, maybe has a cane or something, and you say, look, this is on the second floor, and I don't think this unit would be right for you. And so you don't rent to that person. That would be considered discrimination. So you have made the decision for that person that unit is not right for that person, and therefore have not rented that person. So you've discouraged that person from renting that particular unit. So the same goes for the obvious ones. You're not renting to someone based on color,
right,
or based on their race. Those are all no-nos and against the law.
Is this no matter where your property is? I mean, or is it state by state has different rules?
Again, so there's a broad federal fair housing law.
Okay.
Those are some real basic protected classes. There's about 8 or 9 or 10 of them under federal law. Now, depending on the state you're in, it's expanded. Like California, for instance, adds about another 10 to a dozen protected classes. And if you go into like a local jurisdiction like San Francisco, for instance, they're going to add even more protected classes. So I believe in San Francisco, you're up to about 25, 26 protected classes. And those classes, you cannot, as the landlord or property manager or owner, cannot operate your business such that you're excluding or unfairly treating any individuals based on those characteristics or classes.
So when you're dealing with your clients, are you advising them that they better know, what these protected classes are if they're in that business, and make sure they're not, doing something they shouldn't?
Yeah.
And list somewhere?
Yeah. So generally, I do a lot of teaching in this particular area. So education. And yes, so one of the things I do is educate as to what the particular protected classes are. And basically, really, just the rule of thumb is to treat everyone the same.
Right.
And don't, and it's like, let me put it this way. So the fair housing laws apply. Now I'm going to focus mostly on landlord-tenant right now. So the fair housing laws kick in at the very outset, the application process. So if someone comes to you as the landlord and seeks to rent a unit, treat that person as you would any other applicant. Don't look at that person, based on any certain characteristic like race or disability or anything, or even citizenship. Again, that is a protected class now. So as long as you you put everyone in the same pool and treat everyone the same, then you're usually okay. Now there are some exceptions to that, and I'll talk about that in a minute. But in general, so long as you treat everyone the same, you're generally okay. And let me give you an example. So I had a client come to me who had been, a claim had been asserted against that person for an advertisement that they had. So again, remember I said it starts at the application process.
Right.
It actually starts even before that, the advertisement process. You're advertising a unit for rent. And this was a very small San Francisco studio. As you can imagine, in a cramped environment, there's probably some pretty small studios. And as I recall, this one was particularly small, 400 square, or even smaller than that, I believe. And so my client had an advertisement that said, hey, this unit, it's a small studio in a great location, perfect for a single person. That's it. Sounds pretty harmless. Well, what happened was that person had a claim asserted against them based on that advertisement, because what that advertisement did was it had the effect or the potential effect of excluding either married persons or persons with families from applying. So while the unit could be perfect for a single person, that's not really up to the housing provider to decide. So you market that, look, it's a small studio, 400 square feet, all applicants welcome. And then a family comes in, hey, look, it's me and my wife and my child. Well, once you say, well, it's kind of small and it may not be suitable for that number of people, right there you have potentially violated fair housing laws, because you have potentially excluded a protected class of you protected someone in a group of family status is a protected class.
So what do? Say nothing and just don't rent to them?
No, you cannot not rent to them based on that protected class. So
what do you do?
It would ultimately be up to the tenant to decide. They come, they look at it. What, this place is too small for us. We're going to go look somewhere else. Okay. So really, it's the landlord's obligation to just make the unit available and then not have any advertisements or solicitations or any communications that would purport to have the effect, even the effect, of preventing a protected class from applying.
But that sounds crazy to me, because what if a couple shows up and they've got 10 kids and they say, oh, this is great, we're going to have 5 bunk beds, this is wonderful. I mean, how do you, that sounds insane to me. How do you prevent that scenario from happening if you can't rent to them?
Yeah, well, now there may be some occupancy limits under local codes. Like, for instance, San Francisco limits the number of people that can live in particular size units.
Oh, okay.
And depending on the size of the family, that may violate that. But even under those circumstances, you would generally let the tenant make that decision, and probably the tenant will. They're not going to move that number of people in. What I have seen, and this is where it gets scary, this is why I say you probably do not want to tell that group with, who's going to put a bunch of bunk beds in there that know they can't do that, they can't move their family in, because they may not even be a legitimate tenant. There are tester groups out there who specifically target these types of advertisements and make calls and follow up. Hey, well, look, I've got some kids. Can I come by and take a look?
Really?
And once you say no, that target group, that group that's out there targeting potential discrimination, they then file the claim.
What is this claim? Is it a lawsuit? Will they sue?
Yeah, they can. What typically the way it happens is they file a claim with the Department of Fair Employment and Housing, the DFEH, and then they then initiate a claim. So it's almost like it's not really a lawsuit, but it's a claim against the landlord or the owner saying, look, a discrimination claim has been made. How do you respond? And then they investigate. And then they will issue a right to sue or not to sue at some point, saying they don't find discrimination or they have found discrimination, and then a lawsuit can ultimately be filed. So that's oftentimes one of the first steps in these types of fair housing claims, particularly when it's a tester group. Now, That doesn't mean that the prospective protected person who was discriminated against can't go right to court, because they can. And I have seen that as well. But a lot of times you do see them go through the fair housing organization, like the Department of Fair Employment and Housing, with these particular claims.
Unbelievable. And you mentioned a minute ago that you were jumping into a landlord-tenant issue, and I know also you said disability rules are a big deal right now. So what do you got to say about those?
Yeah, just one point, another illustration. I mentioned that other type of a claim that we saw just at the application process. I just got done defending a client in a discrimination housing claim where the tenant had been there for 10 years. And the landlord in that situation, at the beginning, had told the tenant that the place was kind of small for the tenant, and that the landlord would let the tenant know when a larger place opened up in the unit so that they could move to that particular unit. And that did happen. And the landlord then said, hey, the bigger place is open, why don't you move over here? The tenant didn't want to. They'd now been entrenched in that unit. And the landlord said, well, look, no, I think you need to leave this unit because it's too small for you. And that right there was a discrimination against a family, because the person had several children, and the landlord was taking the position the unit was too small. So that was actually a federal lawsuit that was filed against my client. So it can be very serious. And there was a real significant amount of potential liability in that case that ended up resulting in a settlement that required a pretty big check to be cut by an insurance company to settle that particular case. And I will say that many insurance policies do not cover discrimination claims. So that is
interesting.
A real potential problem for liability for the landlord. So while you can get all the types of insurance you want, you may not have insurance that protects you for discrimination.
Yeah.
Which you may want to look into other areas of asset protection for that particular type of issue that may arise. But now to my light just turned off. Can you still see me okay?
Yeah, you're good.
My light just clicked off in my office here. But so here's now this is the big issue that is a hot topic in my area of practice, and this is disability accommodation. Now, remember, the fair housing laws are very broad, and they include not discriminating against someone based on a disability. And why this is significant is because, have you seen dogs in restaurants or on airplanes or airports or places where animals have historically been prohibited? I'm sure you've seen that. And so why is that? Well,
comfort dogs.
Comfort animals, service animals, you're right. And the reason is because of disability protection laws. And the same is true in housing. A person with a disability has an equal right to use and enjoy a unit. And a landlord in California has a duty or an obligation to reasonably accommodate someone with a disability. So a tenant can come forward and say, look, I have stress, anxiety, depression, whatever it may be, and my doctor has prescribed a comfort animal, like you mentioned, a comfort animal to alleviate the symptoms of my disability. And the landlord is pretty much, their hands are tied in that situation, so long as a disability is established. And the definition of disability is extremely broad. It is anything which impacts anything that impacts a major life activity. So it can be an impairment that is physical or mental. So a physical or mental impairment that limits a major life activity. So traditionally people have thought, well, my tenant's not disabled because I see him walk up and down the steps all the day, every day. That doesn't mean they're not disabled. They could have a mental impairment that limits the life activity, like depression, post-traumatic stress disorder. There's all kinds of mental impairments that you may not see that a tenant may have. And if they establish that and they request some sort of accommodation for that disability, the landlord or the owner has to consider that accommodation, and if it's reasonable, provide it.
It's amazing. There's certainly, if you're in that business of owning rental income property, a lot to know. My takeaways are, is take one of your classes, but maybe we'll do one of those next time, is go through the protected classes and we can talk to you about that. But my takeaway is understand the protected classes, especially in certain hot button areas like, California. And then the disability one is really one you ought to know about. And once you know that, do the right thing and run a clean business. And would you say that's a good takeaway?
Yeah, it's a good summary. Just be aware of the fair housing laws. Treat everyone equally. And like I said, the exception to everyone equally is like a disability. You're accommodating someone. So you may be allowing a tenant in a non-pet building to have an animal as an accommodation for disability, whereas you may not allow other tenants who don't have a disability to not have pets.
Right.
So
right.
Yes, know the fair housing laws and abide by them, and understand that you may have to make accommodations for persons with disabilities. And by accommodation, I mean you may have to alter your rules and policies and practices. So like I said, you may have a no pet policy, and an accommodation may require you to make an alteration to that particular policy and allow someone to have an animal. And another hot area in California, as you can imagine, is the marijuana laws.
Oh.
Have now become legal recreationally in California. And even before they became legal, which was just recently, for the last 15 years, I believe, 10 to 15 years, it has been legal in California for medical use. So that kind of ties into the fair housing laws, because a tenant with, and the example I give is with post-traumatic stress disorder, could need, according to a doctor, marijuana to alleviate the symptoms of that stress. And they can come to you as the owner and say, hey, look, I know there's no smoking policy and in the building, but I need this in order to, function and to alleviate my symptoms. And the landlord may have to allow it as an accommodation for that person's disability.
So that's very interesting, because I've heard some stories, from rental property owners about the marijuana thing, where in some jurisdictions it's legal to grow marijuana, certain amounts. And so tenants will set up a grow situation in, the rental property. In this case, it was in a garage.
Yeah.
And the lighting that was set up to provide the heat for the grow was put together with bubble gum and toothpicks. It was a fire waiting to happen.
Yeah.
And there was a big issue over this and lawsuits. So you bring up kind of a hornet's nest. There's a lot of stuff going on there.
Yeah, and I do talks on fair housing. I do talks on reasonable accommodation. I do talks on marijuana and housing, and those are all in and of themselves, 2.5 to 3 hour talks. So this is just in a nutshell here. But you're right. The California law allows you to grow up to 12 marijuana plants within a residential unit for medicinal purposes. But it does not allow you to violate housing codes. Like if there's a fire code where someone is monkeying around with the electrical system, that you can preclude as the landlord. That is not reasonable. If they're going to use some sort of a system that is going to endanger the building or endanger other tenants in order to grow medical marijuana, then you can put a stop to that. But you may not be able to put a stop to the growing of marijuana plants up to 12, and it's up to 24 in San Francisco, for instance.
24 plants?
24 plants in a residential unit, but 12 in general for California. You may not be able to prevent that so long as they're growing them in a manner that it's not damaging the property or violating health and safety codes.
So somebody can rent your unit in California legally. They can, in the garage or wherever they're going to do it, grow 24 plants with all the lighting and the heat to do that. and then they can smoke it in the unit if it's for medical reasons. Is that accurate?
That possibly, again, so long as the lighting system that they have, that's installed. Generally, there are provisions in leases that preclude alterations to property by the tenant. So installing some sort of an electrical system may violate that. Now, you may have to provide a reasonable, allow a reasonable alteration for that as well. But again, it cannot violate any applicable health and safety codes. But the short of your answer is yes, someone can legally grow medical marijuana so long as they're not disturbing the property or disturbing others as well, and smoke marijuana in their units if doing so is a reasonable accommodation for their disability.
Would an insurance policy cover something that happens because of the marijuana scenario? I mean, are we seeing that yet, or?
So that's a good question. Generally, it should, and depends on the policy. But yeah, usually fire would be something that is protected or covered under a policy.
But if somebody's intoxicated, it's always alcohol. We think alcohol. Someone's drunk, someone's wasted, doing something.
Yeah.
But if they're high on the marijuana and something happens, that sounds like a gray area to me.
Well, that is a real, that again is a recipe for a potential, dangerous situation. But again, it depends on the policy. It depends on the facts of the case on a case-by-case basis. But keep this in mind too. Arguably, insurance companies. So, like, if an insurance company was to threaten to cancel a policy because they found out someone was, growing medicinal marijuana within the laws, within the medicinal marijuana laws, they threaten to cancel a policy on that basis. Arguably, the insurance company might be in violation of fair housing laws, because remember, the fair housing laws are very broad and preclude any adverse action in housing that would have the effect or deterrent of adversely impacting someone with a disability. So I have seen situations where insurance policies tend to try and regulate types of dogs or animals in units, and maybe even potentially cancel a policy if there's a dangerous animal. But you have to balance that with the fair housing laws as well, because the fair housing laws don't say, you can have a comfort animal, but that comfort animal is limited to a small 3-pound lap dog. A comfort animal could be a pit bull. So it really is a case-by-case basis, and this is a developing area, and in different different scenarios have different outcomes, and really we're really learning on the go with how insurance policies and different things are treated depending on the circumstances.
What if it's a comfort horse? Is that any different?
Well, now, you know what? It's interesting you bring that, because you always hear about the comfort pony. Again, there is no limit on the type of animal that can be a comfort animal. That being said, there are local laws that restrict livestock and things like that in residential housing. So I think it's pretty safe to say that a horse would not be allowed in a residential house in an urban area. But again, the fair housing laws don't themselves expressly limit the type of animal. And I've looked into this before, and like dangerous animals are usually precluded from particular areas, or wild animals, and the list is pretty comprehensive. And so anything outside your traditional pets typically would not be permitted pursuant to local laws.
Right. Yeah. See, this is awesome information, and we could go on. I know you do your 3-hour workshops. I feel like we could just keep talking. There's so much great information. I'd like to have you back on and maybe drill down on some of these issues.
Sure.
But yeah, thanks for jumping on, and we'll see you next time.
My pleasure. Thanks a lot. Okay. Have a good one.